Turn the lights down low and the drama up. She's late, she's loud, and she live. Woo! You already know who it is. Shades 2, baby. She back again. Crowd lit, vibe on 10. Shade walk in like we back again. News, tea, jokes and spins. She don't do small talk, she go in. From the headlines to the comment section. She call names with no correction. You tuned in, don't act brand new. It's late night, baby, she got that view.
Late night with Shade.
She say what she want, and laughs all day. Live on Shades Tube, press replay. You thought I let game, back again. She say what she want, and laughs all day. Live on Shades Tube, press replay. You thought I left, nah, I'm back again. Popcorn ready, wig on alert. She dropped one line, and somebody hurt. Talk show queen with a side of roast. She run this thing from coast to coast. Late on purpose, still on time. She hit you with shade, then call it a rhyme. Talk smart, talk slick, talk flame. Say the name right, yeah, late night with Shade. She say what she want and laughs all day. Live on Shades Tube, press replay. You thought I left, nah, I'm back again. She say what she want and laughs all day. Live on Shades Tube, press replay. You thought I left, nah, I'm back again. That's right. News, drama, laughs, whatever else you feel like. One mic, one queen. Late night with Shay. On Shades 2. She back again.
It's late night with Shade.
Yeah, she say what she want and laughs all day. Live on Shades 2. Press replay. You thought I left, nah, I'm back again.
It's late night with Shade.
She say what she want and laughs all day. Live on Shades 2. Press replay. You thought I left, nah, I'm back again. Yeah.
All righty, you guys. Thank you so much for tuning in. And this is Shades 2 Late Night Owls Talk Time. And happy and blessed Thursday to everyone. Welcome to everyone in the bushes, everyone who watched us in the replay. Over here in the chat, we got Jermaine in a place to be. What's up, Jermaine? And y'all, if y'all enjoyed this content tonight, make sure you thumbs up, subscribe to the channel, hit the bell notifications, share and leave a comment, and also hype this video up. And if you want to show additional support for this channel, feel free to do a super sticker, super chat, cash app donation at $Shades2, or cop yourself a membership for $4.99 per month. Alrighty, and thanks to all who have donated to Shades 2. Y'all, copyright disclaimer is flowing across the screen. The entire copyright disclaimer is in my bio section of my channel. Okay, all right, so we're going to finish our discussion regarding Karmelo Anthony in the motion for a retrial. Yesterday we were talking about let's make sure I get the name of this right. Let's say something backwards. Okay, hold on. We were talking about that one serious issue that we were discussing last night, and it's the case closed, I believe. Let me check that. I'll make sure I said that right, because I don't know. I thought I saved something last night, but I don't see it here. No, what happened? Hold on, let me make sure I get it in law. Yeah, case closed. I was right. So we were talking about that last night regarding Karmelo Anthony's motion for a retrial. Okay, and we're going to finish that discussion in just 1 second. Okay, 1 minute actually. Let me go ahead and put my background music on and do all of that, because y'all know at nighttime I do not like it to be so quiet like this, because I mean for real you'll fall asleep. Okay, so let's put that background music on real quick. Let's see, we're going to just put on this right here. Let me turn it down. I actually had on the other one last night. Let's see this. I think I'm gonna put that one on. That's a little bit better. Okay, so what we're gonna do, we're gonna go over everything, so you guys can know what I'm talking about, and then we're just gonna tell you a little bit more about all of the stuff that they are doing. Okay. Okay, so let me put this banner up here real quick. I literally just walked through the door about 20 minutes ago, so y'all got to bear with me from work. Okay, let's turn this down a little bit because it's a little bit too loud. Now let's see what y'all said over here. Yeah, the agreement. That's what we're going to talk about. The case. That is the case closed. Okay, the agreement. That agreement was the case closed thing. Okay. So first and foremost, let me just tell you guys what that means. So in law, case closed is administrative status, meaning a lawsuit or criminal charge is no longer act. Hold on. This is the wrong thing right here. Let me, hold on. Hold on, let me get the right thing, because these people, man. Hold on. Oh, y'all. Let me just get this. I don't know what happened to my stuff that I had yesterday saved. Let me get the right stuff. Because see, one thing about it, if you got to know, because they be giving you the wrong thing. I mean, they actually don't give you the wrong thing, but it means something totally different than what we're talking about tonight. Let me see if I can find it again, because they're giving me something else. Hold on, you guys, for 1 second. I'm trying to find the stuff that I had last night. This is this paperwork you gave me, right, Jermaine, right here. I need the stuff that I had last night. I don't know what happened to it. Let's see. I think this may be here. Let me make sure. I have to check this to make sure this is correct. Yeah, I think this is it right here. I think this is the right one. Yeah. Hold on for 1 second. So yeah. So yesterday I was telling you guys about clean case. What am I talking about? Case closed. I've been saying that all day. Okay, what I mean, that means something totally different. Anyway, yesterday I was telling you about the 60-page motion for a new trial that the defense attorneys prepared in order to get Karmelo, or at least try to get him, a retrial. Now, I was telling you guys about a bunch of allegations that they made, but the most serious allegation made by the defense was an accusation that prosecutors reneged on an agreement reached before trial that led to a last minute decision for Anthony not to testify. All right. The motion said prosecutors proposed that both sides promise to try the case clean and to stick to what happened under the tent, bringing up the reputations or characters of Metcalf, Metcalf's twin brother, Hunter Metcalf, and Anthony was out of bounds under that deal. The defense followed this understanding, okay? And that's according to the filing. And it shaped how they approach matters like jury selection, opening statements, testimony, and cross-examination. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain, the motion said. The defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to police. That Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they are not going to let you disrespect them. So that's what some student witnesses stated. And when they did that clean case, that agreement, this could not be stated, because with the case, the clean case, you cannot bring up anything from the past convictions or anything. Everything that you bring up has to do, got to be, the only thing that you can talk about is the stuff that happened underneath that tent, and that's it. Okay? So when the prosecutor did the clean case and had the defendant, the defense agreed to that, that was the understanding, okay? And they reneged. Now, on the final day of evidence in the trial, prosecutors told the defense team the agreement had never contemplated a testifying defendant. So they didn't want the filing states and argued the defense had violated the agreement by mentioning in opening statements that Anthony played chess. The prosecution did not immediately respond to a request for comment. I'm going to do all that, Jermaine. Okay, let me just go over this first. Now, they said if Anthony testified, the motion argued, prosecutors warned that the door to character and other possibly damaging information would almost certainly open. But the thing is, what type of damaging information? Because we were talking about this, we were trying to figure out, why would the defense agree to a clean case if they have, I mean, why would you agree to a clean case preventing you the chance to, to talk about Austin or Hunter's past behavior or any type of stuff they may have gotten into? Why would the defense agree to that? Okay. And like I said before, when you do a clean case, that applies to both the prosecution and the defense. Okay. You cannot bring up anything from the past. You cannot bring up past convictions or anything. You have to stick to everything that happened right under that tent. So the thing is, why would the defense agree to that? And then we kept on just basically trying to figure that out, because we haven't heard that Karmelo Anthony has any type of record or anything. Now, as far as maybe something about it might have happened in school or something, you know how kids get in fights and stuff, something like that could have happened. But I'm just trying to figure out, would that had could that have played a role in why the defense will agree to that clean case? Because not only does this stop, the prosecution from hearing about the past of Karmelo, the jury hearing that, it also stops anything that could be negative, about Austin or his brother's past. The jury won't hear that either. So we're just trying to figure out. I honestly think no one was they weren't really concerned about Karmelo, not the prosecution anyway, period. They were more concerned about not exposing something. They might have been more concerned about not exposing something about Austin or Hunter, or like we just read here, any student witnesses that said these things right here, that Austin and his brother, they were like aggressive and things of that nature. They're not going to take no for an answer. They're not going to let you disrespect them, in other words, and things of that nature. So if they felt like Karmelo disrespected them, then they would basically go off. And so that may be another reason, like I just said, that the prosecutor, brought up that clean case, because they did not want anything to be revealed, anything bad to be revealed about Austin or his brother. No behavior type stuff, no altercations or anything that they got into in school. Because again, if Karmelo had any bad things like that, like say being incarcerated or, just doing some weird stuff, I think people would have already found out about it and it would be plastered everywhere. Okay. Plus, if it was something really serious, there's no way the prosecution would have even said anything about a clean case. So that clean case was basically used to benefit prosecution. And they could have told Karmelo, now I don't know if they did or not, I'm just guessing. They could have told Karmelo, if he has anything in his background, like I just said, fighting at school or something like that, or, maybe, anything. It could be anything. The way a prosecutor would work, especially when it's like a kid and he does not know, or he has never been incarcerated or anything like that, you can easily make that kid think that even minor things could be very detrimental in that case, okay? And make him think that if the jury finds out about it, then, they could use that to help, make their decision if you're guilty or not guilty. And then Jermaine brought up another thing. He said maybe Karmelo did not know about this. I don't know if he did or not. Okay, I just don't know. I don't know if his parents knew or anything, but I'm just trying to figure out, why would the defense agree to a clean case? So on the final day of evidence, like I said, in the trial, prosecutors told the defense team the agreement had never contemplated a testifying defendant. And then the filing states and argued the defense had violated the agreement by mentioning in the opening statements that Anthony played chess. The prosecution did not immediately respond to a request for comment. Now, like I said before, if Anthony testified, the motion argued, prosecutors warned that the door to character and other possible damaging information, what would that be? Okay. Now, given 10 minutes to decide whether to testify, according to the filing, Anthony chose not to take the witness stand. So basically, they scared this kid. That's what it sounds like, because if you're going to say that the door to character and other possible damaging information would be open, getting there. Well, that's probably going to scare Karmelo. And then you got 10 minutes to try to figure out if you want to testify or not. Anyway, the defense also argued that one of the jury's instructions included by Roach encouraged the jury to disregard Anthony's self-defense claim. And that's something else, that's probably pretty much big. And why would he do that? Tell them to disregard Anthony's self-defense claim. They did, honestly, they really did a damn job on this kid in this trial. And I just don't understand how this happened. I know the parents probably didn't know certain things, and I don't really want to say anything about them. So it's just like this. I just don't understand how all of this was pulled off like this, the clean case, all of this stuff. So let me go to this other paperwork real quick, guys, because I'm not going to read all of that stuff right there again. Let's go over here and get the stuff that this man assigned me. Hold on for 1 second, guys. I got to get it. So you said Article 10, right? Let's see here. This little bitty writing. Okay, wait a minute, hold on. They talking about a lot of stuff in this damn paperwork right here. It goes basically in depth about all of this. Let me go ahead to the right area. I wish you would have just highlighted the stuff, the main goodness. So I have to go through all of this stuff. Hold on 1 second, you guys. I'm trying to find the stuff. Oh, they're just basically going through everything that they did too. Hold on, let's see. So, okay. So this goes all the way through everything in detail, okay? Well, let's see what they said. So they said the first ground for a new trial is, just like I said, the trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings without the findings in alternatives required by Waller, Presley, and Stricker. Oh, wow. So like I told y'all about this yesterday, this right here just going into really more details. And so the issue, they said, is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably, I think I said that right, excluded members of the public from a high-profile criminal trial. The court made the findings, Waller versus Georgia 467 U.S. 39, 1984, requires and considered the reasonable alternatives. Then they used Presley versus Georgia. So they did not adhere to the demands for a contemporaneous, I guess, public access. They said they did not. They said the court order gave the general public only 10-minute daily initial admission window left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings, and provided, hold on, let me see what this says right here. No overflow rooms, no audio feed, and no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller complaint, a Waller compliant justification for those restrictions. It said the existing record contains none, nor does the danger end with this case. Hold on, let me go. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision, and stating that it has struck that balance pretty well. Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, and no live stream be treated as an adequate substitute for an open courtroom? The public trial guarantee of the First and Sixth Amendments would be hollowed out in practice. Dang. That is so, Jermaine, when you say that you don't know if they're going to get a retrial, I don't know. They got a lot of stuff in this stuff. They said the restrictions here amounted to a closure of the courtroom imposed without defining the law requires. Defendant does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was forcibly inadequate, the court was required to consider reasonable alternative and make Waller findings before excluding the public. We need to read the Waller findings and see exactly what that is. They said an open courtroom belongs to the people of Texas who found and sustained it. And they said the openingness of a criminal trial is among the oldest and most subtle features of Anglo-American justice. So that's where they get that fair. They said that his trial was not fair, okay, period. So let's see what else they got here, because that's a lot of stuff. We can't read all of this. I'm trying to get to the part where they're talking about the clean case. Damn, this a courtroom may be closed only rarely and only on the showing Waller requires. That's why I tell you, these lawyers be knowing their damn job. I mean, they got everything in this stuff. Let's see what else they got here. And Jermaine, I still don't see. You said it was on 10, right? That public trial stuff, it's like they got 10 pages for that. They said 10 minutes a day did not keep this courtroom open to the public, okay? Man. Let's see what else they got here. Still talking about the courtroom being closed and stuff. So they up here telling you about this. Okay, hold on. Okay. Yeah, I bet you he may get that retrial. All this stuff. Okay, so let me see. I'm way on page 26. Let me go back to 10. You said page 10, Jermaine. You set up here and read all this, Jermaine. This is a lot of stuff, honey. Okay. This is, hold on. I do not see that on page 10. Hold on, let's see what this is. Okay, I do not see where you're on the page you're talking about, Jermaine. Okay, let's see. Hold on. What? Yeah, this is a hot ass. You said exhibit 10. Okay, hold on. Let me read this first. So they're talking about his televised interview. I know I see it in the daggone thing. Where is exhibit 10 at? All you had to do was screenshot that and just give me exhibit 10, so I don't have to search for everything. This is like 193 pages here. I don't even see exhibit 10. I don't even see where that's located at. But they definitely got everything covered in here. That entire trial, just a lot of different things that they see was wrong. The unrecorded agreement, the defense tried its case under that limitation and reliance on an understanding reach off the record. They're talking about that case. What is it called? Hold on, let me get it right. Clean case right now. But you can barely see this little bitty ass writing. Let me see. Hold on, what is that? They said the same off the record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor proposed that the parties try the case clean, based only on what happened under that date, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May the 5th, May the 8th, and May the 11th, and on May the 21st, 2026. The parties presented the understanding to the court itself in chambers off the record to avoid media reporting on bad act evidence. The understanding was memorialized only as a deliberately generic motion in limine, I guess, Limine or limine, can deliver to the court on the first day of trial. It does not appear on the public docket. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. In voir dire, I guess, or dire, on June the 3rd, the defense did not explore with the panel the themes of the descendant's character and aggression it otherwise would have developed. In its opening on June the 4th, it introduced none of them. Through the state's case on June the 4th, 5th, and 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to the public. That Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered. That Austin and Hunter, they are not going to let you disrespect them. And if Austin is about to get into a fight, you can tell in that he could be a bit aggressive at times. And in an abundance of caution, even narrowed the questioning, the understanding permitted. The defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development in the fight or flight response, because the state took that position that such testimony would breach the understanding. Exhibit 10. And that is the clean case where they cannot talk about anything from neither people or the other twin past any past convictions or anything. Everything is just basically focused around what happened under the tent. So, like I said before, I don't understand how the defense could have agreed to that. Anyway, they said the forbearance had a purpose. The payoff was to come in the defense case under the understanding that the prosecution itself repeatedly described it, covering all witness to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pre-trial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence. And as trial counsel has sworn, in this case, the defense would ordinarily depend on the defendant's own account of perception of the threat. And they did not give him that opportunity to defend himself and tell people what happened. Okay, and remember, Jermaine, we were talking about that, and I was like, they should have let him get on that stand so he can tell his side of the daggone story, so the jury can get a feel, if he's telling the truth or if he overreacted or whatever, or if he didn't overreact. If he's not testifying for himself, how can anyone, know, how can they know if he actually, how can they get a perception of him, period? Shit, did they even hear him talk? or anything. So let's see here. So on Monday, June the 8th, the final day of evidence after the defense has spent I think it's voir dire, it's opening the entire cross-examination of the state's case, the first day of its own case, honoring the bargain, the case, the clean case. The lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. In understanding that throughout the months, the defense relied upon it, existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted 10 minutes, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. In that punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May the 11th, after the agreement would operate. Exhibit 10, the state's punishment presentation will be confirmed by the reporter's record. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term, I don't like to say this, repudiated, I guess, was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state. Okay, hold on. As the state, let's see, itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on its own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening, cross-examination, expert designations, or decision framework that had followed from the understanding. That's crazy, man. Right, he did not receive it. So like I said before, I don't see how they could not grant a another retrial. And honestly, hopefully that judge will recuse himself, because I don't see why he wouldn't. I just don't see why he wouldn't. They got a lot of stuff on here, you guys. Damn. So let's read this part right here. So they got how they did the scheduling, the schedule so fast by having court on a Saturday. All right. And 10 minutes to decide. They said the trial itself was run at speed. At the May 29th conference, the court announced its intentions that the defense began calling witnesses immediately upon the state's resting so that no trial day would go unfulfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties' understanding described above is set out fully in Part 5 below. It erupted on Monday, June the 8th, the final day of evidence, when the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify. The court allotted the defense 10 minutes to counsel. A 19-year-old threw it and denied counsel's request for additional time. What? That's crazy, man. They just had it in for Karmelo Anthony. The defense rested that day after the shortened section, and the jurors were sequestered, if I know I just butchered that word, overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. Now, on Tuesday, June the 9th, 2026, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronology, the order that they went in, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. So they claim they got a missing record. So after the verdict, the sealed file, the missing record, and the televised defense of the closure. Let's see what they're talking about. So they seal, if I got this right, they seal, the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A conditioned counsel could not give, leaving the file available only in chambers. So hold on, let's go back to this. So after the verdict, the seal was filed, the seal file, the missing record, and the televised defense of the closure. So they said the secrecy outlasted the verdict. Trial counsel withdrew on June the 10th, 2026. Appointed appellate counsel was then replaced, and present counsel were substituted. And on June the 23rd, 2026, all while the 30-day deadline for this motion ran. The reporter's records remain wholly untranscribed, and the pleadings in case files set in the court's chambers rather than in the district clerk's public record. sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. And they said a conditioned counsel could not give, leaving the file available only in chambers. So I guess that's why we couldn't get anything about the trial, transcription. What do you call that? Transcriptions or whatever you call that. Couldn't get none of that. Then they started talking about the judge. It said 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions. He described the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes think maybe he should have, he should have at least audio stream or something so people could hear it, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? They're doing that anyway, though. They're talking about it anyway. In a written statement to Fox News, the judge added, now that the trial is over, it is important to me to provide transparency. And in a public letter of June 17, 2026, he thanked the other judges of the country for adjusting their own dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Oh my God, he sure was. Okay, we'll try to get to that. Let me just finish reading. This is a lot of stuff. Okay, wait a minute, hold on. Because the reporter's record of the trial had not been prepared, the official court reporter has advised counsel that no portion of the trial had been transcribed. Okay. What? Because the reporter's record of the trial had not been prepared, the official court reporter has advised counsel that no portion of the trial had been transcribed. And because the case file has been held in chambers rather than in the district clerk's public record, the recitation, I guess that's how you pronounce that, or recitation, I think it's recitation. Yeah, recitation. RECITATION. I think that's recitation. I think. Anyway, the recitation above is drawn from the indictment, the court charge, the public docket, the court's own orders and public statements, the attached affidavits and declarations, and counsel's knowledge. The defendant will offer evidence at the hearing in support of the grounds timely raised hereon. They got all types of shit on here, y'all. I'm not gonna lie. Well, let's see what they said. Man, let's see what else they got here. This is a lot of stuff. Okay, so you said go to what? Page 134. Let's see. Man, it's a lot of stuff. I should have I should have made copies of this shit. This is a lot. Let's see. What's up, Bronze? He definitely was. But I said that from the start because the first thing I was wondering is why. No, it was a couple things. I was wondering, first and foremost, why didn't they let Carmelo testify? Okay? Because you can plead your own case better than anyone. Next, I was wondering why the defense did not cross-examine the witnesses, right? And bring up, what they said before. But we know why now. Okay, we know why now. Okay, so you told me to go to page, oh man, 134. Let me go down. So it's a lot of damn paperwork here. 134. Okay, this is 193 pages, y'all. So they sat down and typed all this up. He said page 134. What's this right here? Oh, they were showing damn courthouse, the seat and everything. They got everything in this. They even got subpoena. Let's see. State application for subpoena. What's all this stuff right here? Hold on. Hold on. Let's see what they got right here, you guys. Well, that's what they got here. Okay, the subpoena for him. Man. Everything here, man. Hold on, y'all. Let me get to this damn page. I'm going to sit up here reading all this stuff. This is a lot of stuff. They're going through the whole damn everything. We got Judge Roach interviewing here, everything. Y'all need to go take a look at all this stuff for real, for real. Damn, I didn't know it was this much stuff here. What is this right here? Oh, that's when he got his what's the name? Okay, hold on. So Judge Roach wrote a thank you letter to who? Let me see what this says. Damn it. Let me read this real quick, y'all. I just made a mistake and put this little ass on. I went all the way backwards by mistake. That's one thing about it. When you're reading this PDF files and shit, if you do the wrong movement, it starts all the way, it goes backwards. Who is that thank you letter to? So now they got evidence here. They got this daggone text, not text, but this post. I guess this is IG. I don't know if this is Instagram or X, where it says Judge John Roach tells me he released the evidence because I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. So they got proof that they sent proof in this packaging that he did do this. Damn. Then here's the thank you letter from Judge John Roach. So he says, the presiding judge of the 296th District Court during the recent trial of State of Texas versus Karmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental responsibility, ensuring the fair an orderly and secure administration of justice. And then he goes on and on and on. Damn, this is a long ass letter too. So they got all this into evidence, exhibit. Okay, now let me go to here. Damn, I forgot what page now. Okay, hold on. This is a lot of stuff, y'all. Damn. Hold on, let me get to 134. It's gonna take some time, y'all, so bear with me. Okay, we almost here. 134. Let's not knock it off here, Shades, dude. So what did you say I'm looking for here in 134? Exhibit 10. Oh, let me read this shit right here, y'all. How about I need to screenshot this? Hold on. What? Let me read this. This a little bit ass writing. Hold on. So they said they discussed that on the phone. Is that the hold on, let me see what agreement they're talking about. That's not the case. What do you call that? The clean case thing that they discussed over the phone, huh? Well, let me read this out loud. Hold on, let's see this. Hold on, Jermaine. Hey, Ada, what's up? So yeah, this is it right here. So let me. Oh God, this is a lot. So this says. So excuse any errors or whatever when I say certain things because this is law terminology, okay? And unless you speak it every day, you may not know these words. So here we go. Before me, the undersigned notary public on this day personally appeared Mike Howard, who, being by me duly sworn, deposed is stated as follows. And remember, this is in very tiny writing, and I'm trying to maximize it so I can see it better. And you have to scroll over and all that. Mike Howard, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated herein, and that they are true and correct. I declare that. I was the trial counsel, supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Maula, who represented Karmelo Anthony in cause number. I don't know if they mean case number because here they got cause number. I'm just going to read this like they got it. 296-835-65-2025, leading up to the June 1st, 2026 trial of this case. The defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offenses, bad acts, evidence related to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, hereafter referred to as the agreement. Let me stop right there. Why would they add Hunter's name to this? Anyway, the lead prosecutor in the case, Bill Worskine, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Worskine proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent at Kaikendo Stadium on April the 2nd, 2025, and not go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. On May the 5th, 2026, Mr. Shook and Mr. Rorsky discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Rorsky discussed the evidence of character, reputation, and extraneous offenses, bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. So what kind of bad conduct or reputation or anything did these boys have? Because if they do a retrial, they're not going to do another case clean for sure, right? Make sure I say that right. Another clean case. I can never get that right. They're not going to do another clean case at all agreement. Okay, so then if they get a retrial, if I got this right, if they do a retrial, okay, then that means that Karmelo can get up there and testify. They can get all those student witnesses back up there, cross-examine them, bring up the statements that they made when all of this happened and everything. And then y'all going to see the truth come out. You're going to see. Because now they will be able to tell you any type of things that they did in the past that may, have some bearings on what happened that day. Could be, like for example, if someone likes to bully or fight all the damn time and be aggressive, that can tell a lot, okay? And that can apply to either one of those boys. Let's see here. So on May the 5th, 2026, Mr. Shook and Mr. Rorsky discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Rorsky discussed the evidence of character, reputation, and extraneous offense, bad conduct as it applied to both the twins and to Karmelo. Mr. Rorsky reiterated that he would be happy to try this without getting into character at all, just on what happened today of the track meet. So why did he want to get into character at all? Okay. And again, let's see who Mr. Rorsky is. Hold on. That's the lead prosecutor. So he was definitely okay. So he said he would be happy if they did not get into that at all, right? Get into their character at all. And why? Why would the lead prosecutor say this if he believes, or if he says Hunter and Austin were just basically good kids, they didn't do nothing, they did good in school, they didn't get into a fight or none of that stuff, just good kids. And what does Karmelo, his background, why did the defense agree to this? Did Karmelo have something that they did not want to come out? Maybe he was fighting in school, I don't know. But it's kind of weird. I mean, it's weird. Okay, we'll look at that in a minute. You said this agreement kneecap, but how? We know it kneecap, but why do you think the defense agreed to this? Because of, we haven't heard anything bad about Karmelo. Like I said, if he got into any fights, kids get into fights in school sometimes. It doesn't mean they're bad. It just depends. Somebody could hit them first and they had to fight them back. You know what I'm saying? Somebody could be picking with them or whatever. But So that wouldn't be all that bad. But a prosecutor would make it sound like it's bad just to get, to make the like Carmelo get scared because he doesn't know. You know what I'm saying? So you can easily make something seem like it's worse than what it actually is. Okay? Because I'm just trying to figure out how the defense agreed to this. So let's see what else they got. So they said on May the 8th, 2026, the defense and prosecution teams met in the Collin County grand jury room. The prosecution team gave us a document entitled State Notice of Intent to Use Extraneous Offenses, hereinafter state notice. And we gave to them a document entitled Anthony's Motion in Limine, I don't know how you said that, Limine, Limini, regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule, and evidence under Texas Code. Let me make sure this goes together. Under Texas Code, et cetera, et cetera, et cetera. Okay. After tendering to each other our respective extraneous filings and briefings, we then discussed the proposed agreement, which the lead prosecutor referred to as the gentleman's agreement. What? I can't. So this lead prosecutor, Mr. Worsky, I know I'm saying his name crazy, y'all, outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the twins or Karmelo Anthony. Just try the case based on what happened under the tent. And during another description, during that meeting, what happened on the day of the incident, seeking clarification, I asked if Mr. Rorsky confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses or acts related to violence and bullying, inclusive of discipline and write-ups. Write-ups in the Metcalf twin school records within this framework. I knew it. I knew that's why they did that damn thing, to hide all of that. Because see, on social media, so everybody on social media was not lying. Okay, everybody on social media was not lying. Okay, when they were saying that allegedly these twins were bullies. Okay, related to violence. Let me read that over for you guys. Hold on, let me make sure I don't lose this. Damn, as y'all know how Shades Tube is. And I lost the whole damn article and they be looking crazy. Let me just screenshot it because y'all know that I be doing the most when I be reading shit off this phone. I had to screenshot it just in case I lose it. Okay, let's see. Let's read this again because I got to enlarge. And next time, Jermaine, we need to print this out because it's easier if you just print it out, as Staples or something. I'm not going to print it out at home because that's too much paper, but damn, in ink, shit, all these pages. But anyway, let's see here. So they called the lead prosecutor, referred to this as a gentleman's agreement. The clean case. So let me go back up to it. Yeah, I said it right this time. The clean case. He referred to that as the gentleman's agreement. Okay. So then he outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the twins, the Metcalf twins, or Karmelo Anthony. And just try the case based on what happened under the tent. And during another description, during that meeting, what happened on the day of the incident, seeking clarification. I asked if Mr. Worshsky confirmed that this would mean that the defense would not go into evidence, oh my God, my eyes, relating to the Metcalf trans character, reputation, and extraneous offenses related to violence and bullying, inclusive of the discipline and write-ups in the Metcalf trans school records within this framework. As well as, check this out, y'all. Y'all remember when somebody said that one of them called, allegedly, one of them called Karmelo Anthony the N-word. Okay, so here we go right here. Okay, so I'll stop that with the framework as well as racism and its change. The prosecution would not go into character, reputation, and extraneous offenses acts, evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. So what was on Carmelo's phone? And so disciplinary records, did he have anything in his disciplinary records that could be looked at in a bad way? Because other than the possibility of maybe fighting or bringing a knife, but if he took a knife to school, that means he would have gotten expelled. So I doubt that was there. And if he would have did that anyway, I don't think the prosecution would have wanted that. Let me go back to it. Oh God, my eyes, y'all. The prosecution would not even suggested this gentleman agreement, aka the clean case. They would have never, he would have never agreed to that if Karmelo got in trouble for bringing a, you know what, to school. They would have definitely used that, okay, to show that he's violent, okay? So I don't believe that. Maybe he got into some type of physical altercation, like fights or something. And I want to know what was on that phone. Okay, so nothing about his phone. They said no, inclusive of the contents of Karmelo Anthony's phone and his disciplinary records. And they, you know, in this you're telling on everything anyway, because with the Metcalf trans, they said nothing related to violence or bullying or being racist or anything. So what the hell happened? And you know, I really truly hope they do that retrial. Okay, let's see what else they got here. So anyway, he said, at this meeting, I sought clarification on how this agreement would work practically, specifically, how to handle the possibility of opening the door to this evidence from either side. Now, during this meeting, Mr. Worshsky repeatedly expressed his concerns that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witness interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf trans being passionate, triggered, and not tolerating being disrespected. Mr. Worshsky eventually agreed that question narrowly tailored to ask about specific statements the witness made to police about the incident under the tent on April the 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident would not constitute kicking open your own door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, but clearly, okay, so that's why they said it was basically I don't know, he reneged. Okay, because then later on, if I got this right, they did not allow them to cross-examine the witnesses, right? So anyway, I said during this meeting, we discussed the terms of the agreement, being that testimony from eyewitnesses from under the memorial tent on April the 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April the 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecution only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocent phase. They stated if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they consider expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense act evidence. Let's see what y'all said. But what is, oh my God, my eyes. What is that they don't want to come out about Karmelo? And at the same time, they don't want stuff to come out about the boys either, because they just said they don't want anything about, to come out about, being a bully or any violence or racism. That's what they said. Yeah, look, I think it's just more behind this whole entire thing. And I said that from day one to Jermaine. I mean, this stuff is weird. Because let me say something. When Karmelo was asked to come underneath the tent, right? If Eddie knows that Hunter and Austin can be aggressive, why would he even have Karmelo come underneath that tent? And when Karmelo was discussing with Eddie, they were talking, and I guess that's when he said the team is ass. I wonder if someone texts Hunter and told him that's what Karmelo was saying. And then Hunter walked over there to see who this kid was and all this other stuff. I'm just guessing, because I really do believe there's more stuff going on with this right here. This is weird. Because I'm saying this because why don't they want the contents of Karmelo Anthony's phone revealed? And what type of disciplinary thing did he get into in school, if any? And then what about Austin and Hunter? The violence, the bully, and the racism stuff. That's why the prosecution wanted this clean case, aka gentleman's agreement. So what do you think could be on his phone that they didn't want to get out to the public? And I don't think it may not be nothing drastic, because if it is something drastic, they would be still trying to hide that. You know what I'm saying? Because when you go do this, if that retrial gets approved, right, if it gets granted, all of that will come out in the first place. The only thing I don't want to say, okay, so when a Hunter came over there, what was he was he texting because the other witness claimed that Anthony was on his phone. So let's see what else we got going on here. So they said on May the 11th, 2026, Mr. Worst Guy, Jury Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. So they did. Hold on, let's see if they had that conversation. During this phone conversation, Mr. Worst Guy confirmed that the agreement would extend to the sentencing phase of trial as well. Mr. Worst Guy said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegation listed in the state's notice. Mr. Worst Guy said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worst Guy agreed that the agreement would cover Mr. Anthony's mother testifying to the standard. I love my son, please show him mercy type of testimony, but no further. So they basically told her what to say, just like I said. Let's see here. So on May the 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt, innocent, and sentencing phase, as long as no doors are open or false impressions given. We agree that the best way to document such an agreement will be for the defense to draft a file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses, so it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May the 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worst Guy by email. It was hand-delivered to the judge on the opening day of trial. Okay, and that word that I'm trying to say, limine, I don't know how you pronounce it, Limine, okay? So then it said defense's understanding of the agreement. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that happened between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 22nd, 2025. So why did they say in their teammates? So it says right here, the defense understands the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that happened between Carmelo and the Metcalf twins and their teammates. So what did the teammates do underneath the tent? Because why would they say that? The only thing that they could have just said this right here. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that happened between Mr. Anthony and the Metcalf twins under the memorial tent on April 2nd, 2025. So, but why did they include in their teammates? Does that, hey, Nate, what's up, what's up, what's up? Does that mean that the teammates were doing something too? Because remember, that one dude said that the twins and some other players or whatever, runners, whatever, kids jumped in too. But we can't really tell what all happened with that grainy video footage. And I don't see that. I only see maybe 2 or 3 people. Okay, that's all I saw, about 3 people, maybe 4. But I definitely saw more than, at least more than one. I'm going to just say that straight up. So let's see here. So as every description by Mr. Worskine described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worskine repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony just as it would any other eyewitness to the incident under the tent on April 2nd, 2025. So why didn't they want Anthony to get up there and testify for himself? The prosecution didn't want him to testify. Now, following the plain meaning of Mr. Worskine's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses, such as the memorial students underneath the tent at the time of the incident, Hunter, Metcalf, students outside the memorial tent who looked over and witnessed the incident, in Karmelo Anthony. So why weren't all these people called up on the stand and cross-examined and everything because of the case clean? Because of this right here. Excuse me, the clean case. We just going to call it the gentleman's agreement, okay? Because I remember that one. Because of the gentleman's agreement. Let's see. And it's like this was a rush trial as well, because he told him, the judge, I think, let me read this up here. He said he voiced concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify would not be available on Saturday, June the 6th. So why would they still have court on June the 6th if defense says some of the witnesses would not be there to testify? He said, I may not have enough witnesses available to fill up a full day of testimony. And then he said, I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. And that client is who? Karmelo Anthony. And this is why they are using this gentleman's agreement as one of the most important things to use in order for them to grant a retrial. So he said they forced the. Let me just read this. Damn, this is a lot of stuff. So on Friday, June the 5th, okay, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Rorsky, the lead prosecutor, about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Rorsky informed me that he was moving more quickly than he had initially estimated. So the prosecution was on track to arrest this case in chief midday Saturday. In this conversation with Mr. Rorsky, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we may be forced to call our client out of order. This time, I did not preface this statement with the perfunctory, like in any case, I won't know if I am going to call my client at the last minute because I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense intention to call Mr. Anthony to testify and how the judge proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June the 5th, this conversation with Mr. Rorsky happened. But it must have happened just before noon because I then sent an email to Michael Mala describing the problem we were facing and asking him to draft a brief for us to argue to the judge that he could not force us to call our client out of order. So, I mean, damn. So basically, you have the trial on Saturday, right? Because you know that some of the defense witnesses can't come. So that's going to make Karmelo's case look weak, because you don't have any type of witnesses to come and tell, what they saw or whatever the case is under the tent. Because remember, they could not go into his character or anything like that. They had to just discuss whatever happened under the tent. Oh, man. Let's see what else. Oh, man, I made a mistake. I knew I was going to do this. Let's go back to 137. And I'm still checking this violence. And what type of violence are they talking about in regards to the Metcalf twins? And we know what bullying is. It was one incident, but the mom basically, admitted that was true, but she, kind of brushed it off. Like, it's like, boys will be boys type thing. It's when he was, I forgot where they were at. And I think one of them called the girl, out of her name or something like that. It was a trip. So let's see what else we got here. They're still talking about this agreement. This is a lot. I'm not going to read all this because there's a lot of stuff, but hold on. Let's see what they say right here. Let's look at these. Boy, they got a lot. So you know what? Y'all need to read this. Hold on, let's see. So they said throughout the trial, the defense, so he was trying to cross-examine, but he was not allowed to because of the gentleman's agreement. Okay, so let's see. The defense revised its trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness the prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. You heard it right here. You heard it right here. They have a reputation allegedly for violence, for being bullies, and for racism. And then the defense was intending to examine these witnesses about various statements they had made to the police for April the 2nd, 2025, regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples are this. Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation, in the same way he got with some of us, and the mellow kids, something or whatever, and then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin, really a passionate guy. And Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. I have known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If they would have been allowed to do all of this, to cross-examine and get all this out, I honestly don't believe this kid would have been found guilty of murder. Okay, because clearly, if this is true about these boys being bullies and Austin being a bully, having a loud mouth and all this other stuff, and the racism and all that, what does this say? I never did believe the story of they just went over there and the only person that got aggressive is Karmelo. I just didn't believe that. Boys, no. Or they just politely touched that kid. I never believed that. I never believed that. Because I got kids myself. They don't politely touch anybody. Just like I don't believe that kid was fake pretending to record. And what the hell was on Karmelo's phone that they did not want to get out? Remember, we was asking about that phone. And not just his phone. What about the other kids' phones? Did anybody record this? Because I find it very hard that none of these kids grab their phones out of their bags or wherever they were at and start recording to put it up on Instagram or, TikTok or whatever. So they are basically going over all this stuff and all of this paperwork, okay, this document. Look at this shit. On Monday, June the 8th, the defense resumed its case in chief, calling Brandon Stevens and Brandon Lacey. The defense next planned witnesses. The defense subpoenaed and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see that he arrived. This whole trial was a hot ass mess, okay? For real, for real. So in this document, they're going over the whole case. They're going over everything. They're telling you everything that happened, just everything. That gentleman's agreement is something else, though. That right there alone might get that appeal. What I really want to read is the part where he want that judge to recuse himself. Because the thing is, well, we already know why. Because he got up there and he was talking about, you know, what he said, those statements he made, okay? So again, let me just stop with this right now because we don't want to be here till 5 o'clock in the morning. Let me just hold this and put this back. Okay. Thank you, Jermaine, for getting all that too. It's a whole bunch, 193 pages, you guys. That's a lot. Okay. There's no way I can go over all of that. But y'all definitely need to read that. Where did you get this information from, Jermaine? Put it in the thing if you can. There are all these things. Let me delete this real quick, y'all. Taking up all my space. Yeah, that is a damn trip. I knew there was no way that when people on social media was coming up with all this different stuff, saying those twins were bullies and, you know, all this other type of stuff allegedly, I just, you know, was wondering if that was true. And I'm still going to be fair. I still want to know what information are they so concerned about on Karmelo's phone. And another thing, did they know of Karmelo Anthony? And again, why did Eddie call him over there if he knew how Hunter and Austin were? And once Hunter came over there, I guess Eddie might have been scared. Who knows? That's why he didn't intervene and try to, you know, stop the situation or whatever the case is. Because if it's true, excuse me, y'all, if it's true that Hunter and Austin are bullies, that could be a reason why Eddie did not intervene and say, that's, you know, come on, y'all, let's not do this, you know, come on, Anthony, let's just go and see what the coach says or whatever, you know, whatever they say as kids, you know what I'm saying? Why didn't he just do any of these things? And another thing too, that boy who ran to that garbage can, at first I didn't think nothing about it, but now that we got all this, I'm beginning to wonder what's up with that. Now, granted, he could have been just throwing some trash away or whatever, you know, because kids are kids. They will run to the garbage can and do the most. But I'm still wondering, is that all he was doing? Okay? Because that was kind of strange to take off. He basically almost fell. Then he threw whatever it was in the garbage can and then ran back. And as far as them, they just said that it was a bunch of kids, some kids outside, you know, like standing outside of the tent that saw that because they looked up at it. So they damn sure could have called all of those kids to be a witness. The defense could have called them all and had it right up there. But of course, you know, that they got derailed. And like they said the prosecution reneged. All of a sudden now, Karmelo Anthony can't testify, but before they said he could because he was underneath the tent. As long as you don't bring up no past behaviors or anything from the past, it's cool because he was under the tent. Then toward the end, you know, they only give him 10 minutes to make up his mind if he wants to testify. After they done damn scared him probably, you know, by telling him certain things. That's cray-cray. So what do y'all think about this? So the strongest issue is the right to testify. Okay? That argument, okay? All right, that's the strongest issue. All right. And like I said yesterday, a defendant has a constitutional right to testify. If the state changed the rules at the last second and that scared him off the stand, the defense has a real appellate issue. Okay? Now, if they can prove the agreement in prejudice, it's going to be stronger on appeal. It's going to be stronger than average, and they can definitely prove it because I just read some stuff to you. Okay, talking on the phone, all this stuff you can that can be proven. And then that off the record proceeding argument that we just went all over. So they said the defense says important pretrial matters happened in the chambers, but not in public. And some motions were hand delivered instead of publicly filed. And that's a no-no. Okay. They argue the public docket did not show what was really happening, so the public could not meaningfully attend or follow the case. No transcription or transcribing, or however you say that. That wasn't done. Remember, they just said that? So in plain English, like I said yesterday, the courts hate secret criminal proceedings, but judges do have power to control security and courtroom access. Okay. Now, and they can, I think they do have evidence to show actual courtroom closure without proper findings. Okay, they do have that. You say it's going to be interesting to see how it turns out. It sure is. So the banning of the public from the courtroom and all that stuff, like I said before, it only have a limited media and the cameras and audios and live streaming were banned. It usually won't win yourself a retrial, okay? However, if they can prove that the courtroom was effectively closed to the public, that's a constitutional problem, okay? And they said this depends on whether the judge shows the judge, depending on whether the record shows the judge made proper findings before restricting access. So, yeah. And then you got that self-defense jury instructions. Okay. Reports say the defense argues the jury was improperly instructed in a way to undermine Karmelo's self-defense claim. That's the part where I read in the paperwork where they said the self-defense thing can't be used or something like that. I think I read. So I mean that's weird. And then they got the lost defense strategy argument. The defense says because they rely on the clean case agreement, aka gentleman's agreement, they did not call experts on epilepsy, threat perception, adolescent brain development, or fight or flight response. So they said that they built the whole trial around one promise. And that one promise was what? To do the gentleman's agreement, right? But to let, okay, as long as they don't bring up nothing from the past or any past convictions or anything about the character or anything, but he can come and testify and talk about exactly what happened underneath that tent. And what they did is they reneged and only gave that boy 10 minutes to make up his mind if he wanted to testify or not. Okay? And then the next one is the recusal motion against Judge Roach. They don't want him to decide the new trial motion because he publicly defended the verdict in his courtroom restrictions, including saying the jury got it right. You can't do all of that. Okay? So the thing is, judges are not supposed to publicly comment themselves on pending issues. Okay? So anyway, the best pathway for them to take, which they are already doing this, is that Karmelo was deprived of a fair process because the defense relied on an off-record agreement. That agreement is the gentleman's, um, agreement. And then the rules changed at the worst possible moment, causing him not to testify. Period. Okay? They definitely did. And those witnesses, I don't know if all lied, but some of them definitely did. Remember, I kept on saying, why didn't they bring up the statements that they made when everything happened a whole year ago? Because these people changed their stories around. How can Karmelo be standing up, then sitting down? He was aggressive, he's not aggressive. Just plainly ridiculous. And then why weren't some of these people who got up on social media who claimed they were there at that stadium and stuff and saw everything, why weren't they called? Too many unanswered questions. I still would like to know what's on his phone. What type of information is on his phone to make or to encourage the defense attorney to go along with the gentleman's agreement? We already know, at least we think we know, why the prosecution did this and presented this to them at all. Because clearly the prosecution did not want Austin or his brother past behavior, situations, or whatever to come out, especially if they did, do any type of violent acts or whatever, or if they were bullies or anything. He did not want that to come out because then that's going to paint a whole different picture of them. And for Karmelo, because then people will start, maybe saying that maybe something more did happen. Maybe they did do more than just put his finger and just slightly push Karmelo. So the thing is, like I just said, this whole entire case, was basically something that should have happened. Not the case with the trial, should have never happened. You know what I'm saying, with these people, because they basically was being, unfair. Period. The judge, all of them. Doesn't even make any sense. They didn't even take them, transcribe anything, none of that stuff. Which is, who the hell does this? And then that lead prosecutor, man. So anyway, we've been on here for almost 2 hours, you guys. That's going to be it. I will talk about this again, obviously, but this is a lot. Like I said, this is 193 pages. I thought it was only 63. 193 pages, and I can only imagine what else is in there. And I'm going to be looking over some of this, probably not tonight, but maybe tomorrow before I go out, or in the morning and stuff when I wake up. But anyway, thank you guys so much for being here. This was a trip. Hopefully now y'all know that it's more to this. And again, I don't believe that Karmelo Anthony just purposely did this. Okay, I believe that something more happened underneath that tent. I believe that some of these kids could have recorded, but they probably don't have it now. You know what I'm saying? But I think, some of them could have recorded it. Certainly Eddie. And I hope it's not more stuff, to this entire situation, this incident, and then it comes out if a retrial is granted. But we will see. I will be keeping you guys updated, and we will finish this discussion probably tomorrow night about Karmelo Anthony and his appeal documents. All right? Thanks to Jermaine, Bronze. Oh my God, I'm tired, y'all. Nate, long time no see. How you been doing, Nate, if you're still here? Why? Jermaine, thank you. A-Dub in the place to be. Thank you. He definitely was railroaded. And thanks for all your help, Jermaine, okay? Thanks to everybody in the bushes, everybody who watched this in the replay. Y'all make sure y'all thumbs up, subscribe to the channel, hit the bell notification, share, leave a comment, and hype this video up. It is almost 3 o'clock, y'all. A.M. It's almost 6 for y'all there, huh? It's Thursday for y'all. It's Thursday for me, too. I don't know what the hell I'm talking about. At nighttime, I started getting sleep. I started talking more bull crap. All right? I mean, making no sense. Anyway, y'all, don't forget to, if y'all want to do a donation, you can do a super sticker, super chat, Cash App donation at $Shades2, or you can copy yourself a membership for $4.99 per month. All right, y'all make sure y'all check out my other material here on YouTube. I do all types of stuff here, from Dollar Tree hauls to Country Rain skits, reactions, live, the Night Owl lives, which are these right here, daily news reactions, which I just pick a random topic and talk about it for about 5 to 10 minutes, sometimes a little longer, but never 30 or 40 minutes. Yeah, like I said, the Dollar Tree hauls, you can check me out on Shades2 Shopping Haul channel to see those, or you can see them over here. And if you want to hear news reactions by Shay, you can check me out here or either on Pressure Point News with Shay. All right? Other than that, y'all, good night for me and everybody who reside on the West Coast. Good night. Is sweet dreams. And for everybody who reside on the East Coast in this daytime, happy and blessed Thursday. And y'all have a good day. All right? All right, y'all. I'm tired as what. Good night, y'all. Peace out. Let me put this back up here first. All right, let me see where is it. Here it is right here. Good night, y'all. Sweet dreams.
Yo, turn the lights down low and the drama up. She's late, she's loud, and she live. Woo! You already know who it is. Shades2, baby. She back again. Crowd lit, vibe on 10. Shay walk in like we back again. News, tea, jokes and spins. She don't do small talk, she go in. From the headlines to the comment section, she call names with no correction. You tuned in, don't act brand new. It's late night, baby, she got that view.
Late night with Shay.
She say what she want and laughs all day. Live on Shades2, press replay. You thought I lacked game, back again.
It's late night with Shay.
She say what she want and laughs all day. Live on Shades2, press replay. You thought I left, nah, I'm back again. Popcorn ready, wig on alert. She dropped one line and somebody hurt. Talk show queen with a side of roast. She run this thing from coast to coast. Late on purpose, still on time. She hit you with shade, then call it a rhyme. Talk smart, talk slick, talk flame. Say the name right, yeah, late night with Shay.
Late night with Shay.
She say what she want and laughs all day. Live on Shades2, press replay. You thought I left, nah, I'm back again.
It's late night with Shay.
She say what she want and laughs all day. Live on Shades2, press replay. You thought I left, nah, I'm back again. That's right. News, drama, laughs, whatever else you feel like. One mic, one queen. Late night with Shay. Shades2, she back again.
It's late night with Shay.
Yeah, she say what she want and laughs all day. Live on Shades2, press replay. Like you thought I left, nah, I'm back again.
It's late night with Shay.
She say what she want and laughs all day. Live on Shades2, press replay. Like you thought I left, nah, I'm back again. Yeah.
All right, y'all. Thanks, A-Dub. And you too, Jermaine. Thank you too. And again, y'all, good night. Happy and blessed Thursday. Good morning to others. And y'all have a beautiful day. And I'm going to bed. It's nighttime here. Hey, good night, y'all. Peace. All right, then, A-Dub. You take care of you. You too, hon. All right.